have Andy Martin, who is president of the board of directors of the Affordable Housing Coalition, Stan Laverman, who's senior housing inspector for the city, and Jim Kringlen, who is managing attorney for the local office of Iowa Legal Aid. So we're going to hear a lot of different perspectives tonight, and I just wanted to remind everybody that this is live streamed, so we're not able to take questions from the audience because the live streaming audience won't be able to hear it. What we're going to do is come around and have a question and answer period at the end where we'll come around with a microphone so that the people online can hear you. If you wanted to jot down any questions you have in your packets, you can do that and just hold the questions till the end. Another announcement. Jim has brought several of these. Legal Aid has published a guide to landlord and tenant law in Iowa. These are usually $20 unless I believe there are some low-income guidelines where they might give them to you free. But if you call Legal Aid, if you want another one of these, you can see if you qualify for a free one, or you can give them $20 for one of these. And we are raffling 4 of them tonight. You'll notice in your folder there is a little ticket, and I have the other side of the ticket here. So between each speaker, we are going to give one of these away. So hang on to the tickets in your folders. Andy, would you like to take it away?
Hello, everybody. As Kristin said, I am Andy Martin, and I am the president of the board of the Johnson County Affordable Housing Coalition. Jessica, our executive director, is right now at the Iowa Finance Authority's Housing Iowa Conference, so I'm sorry you missed her. She has wonderful energy and perhaps a greater depth of knowledge than I do, but I will do my best to answer any questions that anybody has for us. So I am the president of the Johnson County Affordable Housing Coalition. And what we are is an organization that's involved in advocacy, education, and, what's the third one? Education for affordable housing in Johnson County. So we don't do direct service like many of our partners do, but we work with our partners who do direct service, and we are kind of more of a umbrella organization for affordable housing here. And if you want a glimpse into some of the things we do have monthly community meetings. They're on Zoom right now on the Friday at noon on the 4th Friday of every month on just a variety of affordable housing topics. We have guest speakers every month that come in and talk about things, and there's a question and answer period with that. Another thing we have coming up is our annual meeting, and you're all certainly welcome to come to that. It's at Big Grove. It's on Thursday, September 26th from 4:30 to 6 o'clock. So like I said, please join us there. So yeah, education is one of the pillars of our organization, so that's why we're here today, along with advocacy and partnership. So we feel like programs like this are an essential part of what is needed to affect change and get more affordable housing, specifically in this area. So thank you all for listening. And I will turn it over to, I guess, Kristin.
Well, as you know, I'm Kristin Watson, Iowa City Office of Equity and Human Rights. And one thing I want to let everybody know is that this is just barely scratching the surface. There are multi-day conferences on fair housing and fair housing law, and we're trying to squeeze it into an hour and a half. So we are flying at 30,000 feet right now. So please, everybody has a copy of this presentation in your folder. If you have questions, you want to clarify anything or ask questions about details, please call my office. The number is on this slide, and you can talk to me at length about anything that I'm talking about and skimming over tonight. So there are two main laws that affect fair housing and many others that are also peripheral, but the two main ones are the Fair Housing Act and the Americans with Disabilities Act. The Fair Housing Act contains anti-discrimination provisions for all real estate transactions, whether you're buying, selling, renting, any kind of real estate transaction, including advertising. And not explicitly contained in the Fair Housing Act, but contained in interpretations and regulations and HUD memos and things. The Fair Housing Act also applies to emotional support animals. And the ADA provides for service animals. So this is a complex subject in itself, but an emotional support animal is an animal that alleviates symptoms of a disability simply by being there. It provides comfort, it may relieve symptoms of anxiety or other mental conditions, but it is only effective in the home. An emotional support animal doesn't have any legal significance outside of the Fair Housing Act and the home setting. So the ADA provides for service animals, and these animals are also covered in places of public accommodation and so on. So their scope is wider than housing, but the ADA covers service animals. And you might wonder what's the difference, because both animals, service animals and emotional support or therapy animals, both help alleviate symptoms of a disability. But under the ADA, a service animal performs a task, and that task could be related to a mental disability. There are psychiatric service animals, but it also can be related to a physical disability. Your classic example of a service animal is a seeing eye dog. So while there are psychiatric service animals, your emotional support animal is going to only be alleviating symptoms of a psychiatric disability. The ADA also covers reasonable accommodation and reasonable modification of a premises. Reasonable accommodation is a change in a policy, procedure, a rule, something of that nature. A reasonable modification is a structural change. So one really good example of a reasonable accommodation that I do a lot of presentations for landlords, and one of the landlords in a recent presentation wanted to ask if this was a legitimate, reasonable accommodation and wanted to argue, but it is. A woman in this landlord's property received her Social Security disability check on the 10th of the month. And certain types of disability checks come at different times during the month rather than right on the 1st. And this woman received hers on the 10th. So the landlord was constantly wanting to charge her every single month a late fee, because their policy was, if the rent comes in after the 5th, you're late, boom, you get a late fee. She had asked as a reasonable accommodation, could you please simply accept my rent on the 10th without charging me? And the landlord didn't want to do that, but I'm like, yes, that's classic. It is a change, an exception, a modification of a rule or a policy. And it usually doesn't cost anything. That didn't cost the landlord anything to not impose an arbitrary fee. So that is your example of what is a reasonable accommodation. It's something like that, not charging a fee when you otherwise would. Or also classic is providing parking spaces for mobility impaired people. If an apartment complex does not have assigned parking spaces, and there's a mobility impaired person who says, I cannot get to the door. I can drive, I can walk a little way, but I don't qualify for maybe a disabled parking permit, but I still really have trouble walking from the end of the parking lot. That is a very common reasonable accommodation. okay, you can have a parking space for you near the door. That's not a handicap parking space. It's simply an accommodation to the person's inability to walk the entire parking lot. A modification, on the other hand, is a structural change. So, for instance, if you are hearing impaired and need a doorbell that flashes lights instead of it chimes, that is structural because it is attached to the premises. So anything of that nature, generally the tenant pays, although this is a very complicated subject, and I would encourage you, if you have questions about that, to call. But generally, accommodations the landlord pays for, and modifications the tenant pays for. The ADA also covers building accessibility, things like how wide do doorways have to be and elevators and things like that. So when we're talking about fair housing, what we're talking about is what do landlords have to provide to you if you have a disability, or if you don't have a disability, if you belong to a protected class, how does a landlord need to treat you? Unlawful discrimination is treating a person worse than someone else because of the protected class they belong to. And a whole lot of bad things can happen to people, even unfair things, that are not unlawful discrimination. It is only unlawful discrimination if the treatment is because of a protected class and the treatment is worse than others. So also if you're perceived to belong to a protected class. For instance, we had a complaint with a person who was treated terribly because his coworkers believed he was Mexican. He had an accent and he was Hispanic, so he suffered all sorts of terrible behavior based on their belief that he was Mexican. He was actually Honduran, but that doesn't matter. If you're perceived to belong to a class and the treatment is based on that class, then it's still unlawful discrimination. And there's two types of it that I'm going to mention. If this were a law school class, there would be more types. But these are the common types. And this is if you have a personal complaint of discrimination. There's direct evidence. That's the in-your-face stuff that we would hope that by now most people are smart enough not to do, but it's not always so. Sometimes we do get direct evidence. But the most common thing is that we will get indirect evidence. When somebody makes a complaint of discrimination, it's because there are words or actions that don't feel right, don't sound right, feel like there's a discriminatory intent. They create an inference. And if the investigation shows that there's no legitimate purpose, then that is indirect evidence of discrimination. And I won't get into, we don't have time to get into the big back and forth, but a person needs to make a case that, yes, this looks bad. And then the respondent has a chance to say, well, hey, no, I'm sorry, it might look bad, but there really was a legitimate purpose here. And then the person who complains gets a chance to say, wait a minute, no, this legitimate purpose that they came up with is really a smokescreen. So when we're investigating these things, they go back and forth like that. And we do our best to unravel all of the different claims and all the different evidence to see whether it is in fact legitimate or not. So I've been talking a lot about protected classes. And this is a category by which people qualify for protection under the law. And how do these categories get there? It's just whatever any sort of legislative body chooses to protect. You know, there are other cities besides Iowa City who protect different things, and other states besides Iowa who protect different things. I believe Ohio protects veterans status, for instance. You know, a whole number of things that you can possibly protect if you want to as a legislature, and if someone comes to you and lobbies to protect it. But it really is that arbitrary. It's whatever the Congress or the state legislature or the local city council or county board of supervisors decided to protect. And with the Federal Fair Housing Act, also I should mention, this is maybe intuitive, but federal law applies to everyone. So the higher authority applies to everyone. And then as it trickles down to state law, county ordinance, city ordinance, those things apply only in the jurisdiction that you're in. For instance, if I'm in Iowa, I can talk on the phone in the car holding my phone. The minute I cross into Illinois, a different state, Illinois has a hands-free law and you can get a ticket for that. So we have one big country, 50 little countries, and then innumerable counties and cities that have their own ordinances too. The Federal Fair Housing Act covers a surprisingly small amount of things. Race, color, national origin, and religion were the only things that it protected when it was passed in 1968. And incidentally, in 1968, it was passed as a direct result of the assassination of Dr. Martin Luther King, Jr. He was assassinated on April 4th of 1968, and President Lyndon Johnson basically strong-armed Congress. This act had been introduced multiple times over the preceding 2 years, and when Martin Luther King was assassinated, President Johnson basically told Congress, you pass this as a memorial to him or else. And it was passed on April 11th of 1968. But it only covered race, color, national origin, and religion. In 1974, sex was added, and it took until 1988, which is shockingly late, for familial status and disability to be added. And you'll notice that there's a glaring omission. In certain circumstances, in certain interpretations, sex can cover sexual orientation or gender identity, but not always, and it's iffy. It's not as strong, because if you have to interpret something, there's always the chance that the court or the administration is going to interpret it elsewhere or otherwise. So Iowa is one of many states who said, no, look, we're going to make sexual orientation, gender identity explicitly protected. And creed is a protection for a deeply held moral belief that isn't a religion. Frankly, in 17 years of investigating discrimination complaints, I have not had a creed complaint, because usually if you have a creed, it's a religion. But it's there, just to protect people, just in case. Iowa City local ordinance adds age, marital status, public assistance source of income, although that contains a big exception. Section 8, or your housing choice voucher, is not covered under public assistance source of income, because at the federal level, that's a voluntary program. So we actually tried to protect that, and the state legislature knocked us down and said no. So public assistance source of income means other kinds: Social Security, disability, veterans benefits, et cetera. Presence or absence of dependents, you might think, why is that there? Because the federal law protects familial status. But familial status has a very specific definition. It's having or expecting to have children under the age of 18 in your household. So that only protects parents of minor children or people who are in the process of adopting or expecting a child. Iowa City Council said, now wait a minute, people have all sorts of other dependents other than minor children, and also a landlord could possibly favor people with dependents, and a person without dependents could be disfavored. So that's the difference in that presence or absence of dependents versus the familial status protection. And there are, as always in law, some exceptions. And these exceptions are narrow. They are tailored to the purpose of the exception. So like a religious community can exclude people who are not part of that religion. If you have a community of Catholic nuns, for instance, you can exclude someone who is not a Catholic nun. But you can only exclude so far as the legitimate purpose of the exception. So you could not exclude a black nun or an immigrant nun or a nun of a certain age, etc. You can only discriminate in a religious community on the basis of the religion. Housing for older persons, that's the same thing. You can discriminate on the basis of age in housing for older people, but again, you can't discriminate on the basis of race or disability or any of the other protected classes. Owner-occupied housing, people who are living in the same place that they rent, if it's a certain number of units, you can't say I own a 400-unit apartment complex and it's owner-occupied, so all 400 units I can discriminate. It's 4 or fewer units or rooms in a house. But if it is owner-occupied, the owner can say, I want to choose who I want to live with. Although within a strange wrinkle, the owner cannot advertise who they want to live with. So you cannot have an ad that says, no, these people, or I want these people. You have to, if you're the owner, advertise your place, with no exceptions. And then you can choose the tenant that you want. Shared living quarters can only be, you can only discriminate on the basis of sex if the bathing facilities are shared. So if you have a shared living space where people share the bathroom, then you can discriminate on the basis of sex and say, okay, this floor is for men, this floor is for women, etc. And my office takes discrimination complaints, so that's a large part of what we do. This is a very truncated version of the information sheet that we send out when people file a complaint. So it's a lot more than this, and this is kind of confusing because it is so compacted. But when you file a complaint, first thing we do is a jurisdictional review to see if we have jurisdiction over the complaint. It has to be filed within 300 days of the most recent discriminatory act, because if there's a pattern of discrimination, that can go back further than 300 days, but the most recent discriminatory act has to be within 300 days. For our office, the discrimination needs to have taken place in Iowa City. We get lots and lots of people from the surrounding area, Coralville, North Liberty, Tiffin, et cetera. And we will help people. Anyone who walks in the door, we will help. But we won't investigate their complaint. We will give them a form for a state complaint, and we will send their state complaint to the state. But after that, it's the state's responsibility to do the investigation. If we take a complaint and it is jurisdictional, we have to serve it in 7 days, and the respondent has to answer it in 15 days. Then, with that answer, the allegations that are made in the complaint and the answer we have, we decide whether or not we can make a decision or if it needs further investigation. And if it does need further investigation, we will do everything that's needed. And that can consist of a lot of different things. But in the end, we either decide whether it's no probable cause, NPC, or PC, probable cause. And in the interest of space, after PC, it doesn't go directly to a public hearing. We have what's called conciliation. We will tell the respondent, look, we are going to find probable cause, and everything we do is confidential up until a public hearing. So if they want to make it public and fight it publicly, that's fine. But most people choose not to. Most respondents that we say we are going to find probable cause will do what we call a conciliation, which is basically mediation with a stick attached, saying, we have already decided you are in trouble. What are you going to do about it? So that's where most of our probable causes get resolved, if they're not resolved in mediation. In housing, mediation is mandatory and we pay for it. So if you file a housing complaint and it makes it through the jurisdictional review and all of that stuff, we will hire a professional mediator and attempt to work it out between the parties. So that's our office. We do the complaints of discrimination. We do equity policy for the city. We do programming of this nature, news and information, and we are also staffed to the Human Rights Commission and the Truth and Reconciliation Commission. So I've put all of our information there. If you'd like to get on our listserv for our news and information, please send us an email or sign up at icgov.org/humanrights. You can sign up for our listserv there. And I did have a questions slide, but since this is being live streamed, we are holding all the questions to the end.
Hello, everyone. Just testing the sound. It sounds like I'm amplified reasonably well. I'll just introduce myself quickly. My name is Jim Kringlen. I'm the managing attorney of Iowa Legal Aid's office here in Iowa City. So I have a banner here that has our phone number, our toll-free number on the bottom. It's probably not visible to people in the audience here. I'll just say it. It's 800-532-1275. That's a number anyone can call to request free legal assistance.
It's a different number than you have down.
It is. Well, we have more than one. Okay. But the number I said, thank you, the number I said is our main intake application line. The number down there, I'll give it to you also in case anyone sees it. It's 800-532-1503. That will work also. But 532-1275 is the one I have committed to memory. So Iowa Legal Aid is a statewide law firm that provides free legal assistance to low-income and other vulnerable populations in Iowa. We handle only civil cases, so we're like the analog to the public defender. The public defender, they handle criminal cases. We don't do any of that. And so we're only handling civil matters, like housing is one of our biggest categories. It probably is the biggest category. You usually have to be low income, but not always. There's exceptions to everything. That's any lawyer will always offer an exception. I can say something really strong, but then I'll add except, and so that's how it is with the services we provide. Our office is principally responsible for handling cases all in 7 counties, but this is where we are located. And it's the biggest county that we serve, so it's also the largest number of our clients are from Johnson County. Iowa City is probably the biggest number of all the towns in Johnson County, but I haven't actually done the data search on that. So, but I want to start by talking about, very briefly, a fair housing project that we are working on. It's a 3-year project, and what we do with that is all of the cases that come into us, a lot of them are just run-of-the-mill, like landlord-tenant problems. And when we interview people, we'll ask a screening question. Do you think you've been treated differently than others in your housing? And if the answer is yes, that will prompt us to ask some more questions. And so a lot of times we learn of behavior by landlords. Let me start by saying we're not anti-landlord. Most landlords are good people and good landlords. Our clients are predominantly low income, and they probably end up in renting places from landlords that are the least likely to maintain the premises. They're serving people who can afford lower rents, and they themselves might be lower income and have fewer resources of their own. Doesn't mean they don't have the obligation to maintain the premises. They do. So what we end up working with are landlords, some of the worst landlords in every county in Iowa, often. Not always, but often. And so, but I'll give you an example of something that recently came into our office that is not something that most people would necessarily intuit, that this is discrimination. So we had a tenant whose landlord was trying to evict her for non-payment of rent. But there's a whole bunch of facts I'm not going to tell you about, but it was much more complicated than that. But when I was talking with the client, she mentioned that the landlord had said something in a text even to her that referenced sexual behavior. And she's a woman, and so what that means is he was discriminating against her based on her sex. It's illegal. So there are too many landlords that do this sort of thing, where they sexually harass their tenants, their women tenants. So it's illegal. We are running with that one. The landlord, I already successfully defeated the eviction. Landlord had also filed a money judgment case against her, demanding a couple $1,000s in a money judgment. We filed a counterclaim alleging violation of the Fair Housing Act. So that's the sort of thing our Fair Housing Project is looking for and pursuing. There's other cases that involve national origin discrimination, and some of those can be hard, but if the landlord says words or text words that reference the tenant's national origin, that's usually going to be illegitimate, no good reason to do that, and often evidence of discriminating on the basis of national origin. It's prohibited. It's complicated, though. Everything in the law is somewhat complicated. So what I'm going to do now, though, is just go over some basic landlord-tenant law with you. And because we have a live stream audience, I'm not going to ask you all to participate vocally, only just raise your hand if you agree with something, and I'll sort of count how many I see. Almost all of these questions on this quiz I've distributed to the audience here are true-false. So I'm going to say, please raise your hand if you think the answer is true. Please raise your hand if you think the answer is false, and then I'll announce how many I think people have for each of those. Yes, you have a... Yeah, hopefully everybody present has that one-page, two-sided quiz. If you don't, there's more back there. So, I want to also mention, before I forget, there's 4 of these booklets that will be given to 4 lucky winners. 2 have already happened. There's going to be 2 more. This is a guide to landlord-tenant law in Iowa. It's very comprehensive, and even landlords buy this from us. The front of it is written for lay people. It's not in legal language, and it's got some sample notices that tenants might want to give their landlord depending on the problem they're dealing with, and that sort of thing. Lots of information about how Iowa's landlord-tenant law works. The back of it, though, also has the full text of the Iowa Uniform Residential Landlord and Tenant Act, that's legalese. Understanding and interpreting it and applying it is not simple. If you're not a lawyer, it can be a place for you to start. Then I'd go to the booklet and see what the booklet in the front suggests. But a lot of it is if you're not a lawyer, you won't know what some of it means or how to use it. The other chapter of the Iowa Code in the back of these booklets is the eviction statute. It's called forcible entry and detainer. So that's what eviction is in Iowa law. So we also have a separate booklet that's very similar, but important difference is it's in relation to renting mobile home lots. So it's a guide to manufactured and mobile home park law in Iowa. So that's governed by a different chapter of the Iowa Code. That chapter is in the back of this booklet, so if you have a mobile home lot you're renting, this is the one that applies. The same eviction statute applies, although there's some wrinkles that only a lawyer would know about in how those are treated differently in the eviction statute. We also have other booklets on lots of topics of the sort that we handle. A lot of this information is on our website, so I'll mention that. It's iowalegal.org. You don't have to pay anything to read our website. You don't have to be low income to read our website. So we also have booklets on small claims court, rights of debtors, so people who have been sued for money and maybe they're facing a garnishment of their wages or their bank account. We help people try to deal with those or quash those. Divorce law with children, divorce law without children, custody, child custody and visitation in Iowa, and quite a few other topics. We have a hotline for older Iowans also. It's a different number. I don't have that one memorized. If you're 60 or older, you can apply. Even if you're not low income, we have grants with area agencies on aging, so we can almost always give at least legal advice to a senior, 60 or older, in civil matters that we have some knowledge about. So that's enough of the background. I'm just going to tell you, we'll just go over this quiz now. And so the first question on this quiz is not true or false. It's multiple choice. So the answers are going to be A, B, C, D, or E. Okay, so I'm going to, this will be a little bit harder. Those of you here, you've got the written one in front of you. You can hopefully already have your opinion before I ask you to raise your hand if you believe it's A or and so on. So this question is, if the monthly rent is $800, how much can the landlord charge for a security deposit? Rent's $800, so one option is, okay, the landlord can charge A, $400. If you think it's A, $400, raise your hand. Nobody so far. Again, rent is $800. Do you think the answer is B, a landlord can charge $800 for a security deposit? 1, 2, 3, 4, 5, 6, 7. Oh, looks like maybe a majority or at least half of the audience present thinks it's 1 month's rent is the maximum. How about C? Anybody think it's $1,200, 1.5 months rent? There's 1, 2, and then the D is $1,600. 1, 2, 3, 4, 5, 6. So a good number think it's that. Anybody think the answer is E, as much as they want? 4 of you think that. Okay. Well, it's not something you can intuit. You might have heard something on the street and think you know it. I wouldn't know it if I wasn't a legal aid attorney who practiced in this field. The answer is twice the monthly rent. That's the maximum they can charge. So the answer is D, $1,600, if rent is $800. So that's just one of the things that's in the code. If the lease charges more than that, it's prohibited. What the remedy is a different question, right? So if you've paid more than 2 months' rent as a deposit, you might need legal advice about what to do about it. And the other thing, it's a good opportunity to mention that now. I can't give anybody in this room legal advice, okay? Legal advice is something lawyers give to clients. None of you are my clients. At the question and answer period, you might have questions that you want to ask, and I will do my best to answer them, but I don't want you to ask me for legal advice. What's the difference? I'm not going to explain that right now, but I can only give you information that applies to everybody in the room. If you have a specific legal question of your situation, you need a private confidential consultation with a lawyer. It doesn't have to be me. It doesn't have to be Iowa Legal Aid. It could be any lawyer. But that's where the lawyer would probably ask a bunch more questions than your question to me might be very simple. And I will probably ask myself, okay, what don't I know? And I probably don't know more than you've just told me in your question. So I can't give legal advice even if it would be ethical. But again, it's not. So, but I can do my best to answer questions in a general way. All right, here's the first true-false question. A landlord can refuse to rent to tenants with small children since they may cause extra damage or perhaps just make too much noise, and other tenants have been unhappy with noisy children above them, for example. So a landlord can refuse to do that, to rent to tenants with small children. True? Raise your hand if you think it's true. 2 of you think it's true. 3 of you. How many of you think it's false? Almost all of the rest think it's false. Yeah. And that's the correct answer. As the first presenter explained, familial status is protected under the Fair Housing Act. So it is illegal to say, I will rent to anybody except people with children. That's illegal. And so if that were to happen to you, you should know that that's not allowed. Then maybe talk to a lawyer, get legal advice about whether there's good evidence, what the remedies might be, what you could do about it, that sort of thing. The third question, let's move on. It's also true, false. This is a short statement. A rental agreement must be in writing to be legal or enforceable. Raise your hand if you think it's true. It must be in writing. Okay, it looks like most of you, the large majority of you. Do any of you think it's false? It need not be in writing. 2. Yeah, that's a good question to ask because this is counterintuitive apparently. There are lots and lots of enforceable contracts that are oral, verbal contracts. So the answer is false. It does not have to be. Now, it's a good idea to have it in writing because when it's unwritten and the tenant says, I agreed to pay rent of $750, and the landlord says, oh, no, I told you you'd have to pay $850. And then you have this disagreement about what the agreement was, right? And then if the landlord's trying to evict for not paying the full amount, then a judge has to decide at maybe an eviction hearing whose version is correct, who's more believable, that the tenant says rent was agreed to be $750, or the landlord's version that the agreement was rent is $850. And so whenever there's a question like that and the judge has to decide who's more believable, it's harder to predict the outcome, right? I don't know how credible you're going to come across. I don't know what kind of evidence you have. Hopefully you've paid the $750 a couple of times. If you did, that would be really good evidence that the verbal agreement was $750. But if you've never paid $750 and this is the very first month, then it's like, harder question, right? Might be, is there a text message between you where you had this conversation, or emails? That's actually in writing. It's not the whole lease, but it's an important piece of the lease. It's like, how much is rent? That's one of the central key terms of any landlord-tenant lease. So, all right, I forgot to start my timer. I just remembered that. I had it set for 25 minutes. And it's probably been 10, maybe 12 already. So I'm going to set it for 13. We'll see if I can get through the rest of these in 13. Okay. Then The next question is also multiple choice, A, B, C, or D. And D is all of the above. I'll just tell you that right now. So the question is, when you move into a rented apartment or house, it would be a good idea to, A, walk through the premises with the landlord and note any problems. B, write the landlord a letter, keeping a copy for yourself, telling the landlord what is broken, dirty, or otherwise not in good shape when you move in. C, take photos of the premises before you move in, showing any pre-existing damage. Or D, all of the above. All right, so we'll go back to A. Anybody think the right answer is A? Nobody. How about B? Nobody. How about C? No. One thinks C is two thinks C is, no, you're taking it back? Yeah. All right, only maybe one that thinks the answer is C. And then does anybody think it's D then? All of the above. That's the right answer, yes. The thing about taking pictures and that sort of thing is so easy now with cell phones. Almost everybody has a cell phone, right? If you take a picture, they also have date stamps on it, right? It tells you exactly what date and time of day that picture was taken. So that ends up, if you have a dispute about the condition when you're moving out and the landlord's trying to keep your security deposit and you don't think it's right, those photos will be important evidence probably. Little tip, if you do that, email those pictures to yourself. That seems like a weird thing to say, right? Well, what if your phone is lost or broken or, I don't know, you've changed phones? Well, did you email those photos to your email account that you still have? There they are. There they will be. So just something to, a little tip. All right, next is another true-false. If something is broken, but the landlord won't fix it, the best thing to do is stop paying the rent to get the landlord's attention. How many think that is true? That's the best thing to do. One of them. Two of you. Nobody else thinks that. So the rest of you think it's false? That's not the best thing to do? A lot of you think it's false. Yeah, I agree. It's not the best thing to do. There are remedies in the law that tenants have if a landlord won't make repairs that are needed. And lots of times tenants come to us and that's what they've done. Like, I asked them to fix the refrigerator and we still don't have a working refrigerator. It's outrageous. So I didn't pay the rent and I'm not gonna. Okay. I will probably offer to represent them if I'm talking to them, but am I going to win it? I might. We win these sometimes, but they're not easy. It's just not easy. There are other remedies that you can do that might be safer. Like if you end up getting evicted because you didn't pay your rent, that's a pretty fast process. You could also file a lawsuit of your own against the landlord. That usually requires a lawyer. You might not have a lawyer willing to do that, or you might not think to ask a lawyer to do it. If you come to us, there's a reasonable chance we will say we don't have enough resources to do that unless it's a really serious problem. I think a non-working refrigerator is a really serious problem. A non-working furnace, and it's winter. If it's summer, maybe not. Winter, it's a serious problem. Summer, air conditioner's not working. Sometimes it gets extremely hot in Iowa, as you all know, and it might not even be livable to stay in an apartment or a house without air conditioning. It's just sometimes that hot. We might consider that worth it, but we would start with not litigation. We would call and write the landlord and demand they fix it and warn them that we've advised the tenant about their legal rights. And this could get very expensive if they don't fix it. So there are things like that that are safer. If the landlord tries, well, there's a question about this. I almost gave it away. I'm not going to do that. So if a lease says no pets are allowed, but a tenant has had a small dog, just a small one, really small, for 6 months, and the landlord knew the whole time, right? The landlord can't evict the tenant now because of the dog. True or false? True, raise your hand if you think it's true. They can't evict. A few of you, like 3 or 4. The rest of you, do you think it's, no, they could evict you, it's false? Looks like most of you think that. The answer is, see, at least some of these questions are not intuitive. I like that, right? The answer is true. They can't evict you. There's a provision in the Iowa landlord-tenant statute. It's called waiver. If the landlord accepts performance by the tenant that varies from the terms of the rental agreement, your eyes might be glazing over already. I'm just reciting the language of the code. But it says that constitutes a waiver of the landlord's right to terminate the lease for that breach. So you're violating the lease, but the landlord knows about it and they accept it, right? So if they've known about it for 6 months, that's acceptance by any definition I can imagine. So they can't evict you for that. Is it risky anyway? Yeah. I mean, especially if you don't have a lawyer who can raise these defenses affirmatively, because the judge might not come up with it on their own, or the tenant might not know to testify or to offer proof that the landlord knew about it that whole time. These are important things to get the benefit from these defenses. So waiver, we use it a lot to get eviction cases dismissed. Next one is true or false. The landlord can come into the rental unit at any time because he or she owns the building. True? 1, 2. 2 think it's true. They can come in at any time because they own it, after all. Do the rest of you think it's false? Raise your hand. Yeah, the rest of you are right. The Landlord-Tenant Act has very specific provisions about when a landlord can come into the premises, even though they own it. They can't just come barging in any old time they want. Almost all the time, they must give a 24-hour notice at least, right? Now, if there's a plumbing leak or a fire or something emergency is happening, all right, there's an exception for that. There's no way to give 24 hours notice for some things like that. They just need to go in and stop the leak, turn the water off, or put out the fire, or whatever it might be. But normally, they have to give a 24-hour notice. The tenant has to give them access, too. If they say, no, you can't come in, even though you've given me 24 hours notice, the tenant could be liable to the landlord. So you don't want to do that without a really good reason. And they might want to just come in to inspect. Like, I haven't seen the apartment for a few months. I want to make sure things are in good condition, that you're not causing damage, or I want to show it to somebody I'm considering renting it to after you move out. Or I want to have some repairs done or remodeling, measuring for curtains, whatever it might be. They give you the 24-hour notice. They have a right to come in. So next, true false is it is illegal. It is against the law for the landlord to lock out a tenant even if the rent is not paid. Okay, so you got a tenant who's not paid rent in several months, let's say. The landlord can say, I've asked you to pay the rent repeatedly, and still you haven't paid it. I'm changing the locks. So let's say they do that. It is, but the true-false question is, it's illegal for that. Do you think that's true, it's illegal? A lot of you think it's illegal. Anybody think it's not illegal? One of you thinks it's fine. It's not fine. It's expressly prohibited. Landlords, even if they have good reason to be unhappy with the tenant, because the tenant isn't paying like they agreed to pay, they can't take matters into their own hands, right? They have to. That's dangerous if you think about it. Could be a physical altercation. That's why the law says no. We have a court process that people must use. If a tenant won't voluntarily leave, the landlord can't take matters into their own hands. They have to go to the courthouse, file an eviction petition. There'll be a hearing in 7 to 15 days, and the judge will decide who is right and who is wrong. So, all All right. A similar kind of question, but a little different. Instead of locking you out, the question here is, it is illegal for the landlord to take some of the tenant's things because the rent's unpaid. Like, hey, you got a valuable stereo there, and you owe me $2,000 in rent. I'm going to take that and hold it, and that's going to protect me. All right, it's illegal to do that is what the question is. Is it true that that's illegal? Or most of you think it's true that is illegal. Anybody think it's permitted? Yeah, your intuition is correct. It's illegal. Can't do that. Can't take your things because the tenant owes money. That was abolished a long time ago. Used to be allowed maybe in most states. Long time ago. All right, true, false. If a tenant complains to the landlord about things that need to be fixed, the landlord cannot evict the tenant just for that reason. True? Most of you have raised your hands. Anybody think it's not true? It's okay to give us something to talk about. No, nobody thinks it's not true. Nobody thinks it's false. And you were all right. It's just like if you don't pay the rent, they can't lock you out. They can't take your things. If the tenant is asking for things to be fixed, they can't evict you for that, right? Like, I'm tired of hearing your complaints. Here's your notice. Get out of my apartment in 30 days, right? That would be a straight-up illegal retaliation. There's provision in Iowa law that says landlord can't retaliate against a tenant for insisting that their rights be respected. And if the tenant complains to the city inspector or they complain to the landlord, either way, doesn't matter. If you can prove you made a complaint and then they give you a termination notice without a reason, in other words, without saying you violated the lease yourself, that's what we call a prima facie case of illegal retaliation. All right, so if a tenant gets a 3-day notice to quit, that's what the document is called. The tenant has to be out in 3 days, like it says. True, or do you think it's true? One of you? Two of you? Anybody else? 3 of you think it's true. The rest of you think it's not true, apparently. Yeah, it's not true. So that's just the notice to quit is simply the landlord's notice. They must give it before they go to court. They can't just say, oh, that's my time. They can't just say, I have good reason for you to be out. You should be out already, and since you're not, I'm going to court. No, there's a requirement in the code. Got to serve a 3-day notice to quit first. So, and if you're not out, then it's up to a judge to decide. They have to go to court. Again, they can't resort to self-help. So you don't have to be out. If they have to go through a court process, that's going to take a couple weeks, maybe longer. So the answer is no. I still have a page of questions, so I will leave it to the moderator here whether I should continue or call it good enough, and then leave some questions. Yeah, I can give you the answers, you bet. So here we are. Oh, shutting off, number 12 is about, is it legal for a landlord to shut off the water or the electric or gas utilities if the tenant's late on rent and the landlord also just can't afford to pay their utility bills because the tenant hasn't paid. It is not legal. Just like you can't change the locks, you can't turn off the utilities. It's illegal. 13, a landlord can serve a notice ending a tenancy, sending it by certified mail only. Even if the tenant doesn't get it, that's false. Serving notices is a very specific thing. There's ways to do it, but one mailing is not enough. You could send it regular mail and certified mail and post it on the door. Then you've served them 4 days after you mailed it. But otherwise, it's like the landlord didn't give you any notice because you've not been served. If all rent's paid and there's no damage to the premises or cleanup is needed, the landlord has to give the deposit back as soon as the tenant's out. That is false. They have 30 days after you move out and give them your forwarding address. So a lot of people don't know that, and it's a problem for them because they think they're going to get their deposit back immediately. They might, but they don't have to, and they usually don't. Landlord cannot make the tenant pay to clean the carpets after they move out or deduct the cost of carpet cleaning regardless of whether it's dirty. No, there's a case on that. The Supreme Court said no, you can't have an automatic thing like that. If a mobile homeowner rents a lot in a mobile home park, the landlord can raise the lot rent as much as they want, but only after giving 60 days written notice. That's false. They have to give 90 days notice now. 17, can a tenant ask for help from legal aid if they have problems with their landlords? Yes, that is true. And that's all for me. I'll answer questions as best I can at the end.
All right. Last but not least, we have Stan Laverman, Senior Housing Inspector for the City of Iowa City.
I feel I'm following Michelle Obama here, my word. Great presentation, Jim. Appreciate it. Stan Laverman, I'm the Senior Housing Inspector for the City of Iowa City. I've worked for the city for 22 years, which makes me one of the old hats in the office now, which is kind of scary to me. Have been in the housing inspection realm and housing authority for 21 of those years. Have been the Senior Housing Inspector for 14 years. Just a show of hands, are we here as tenants or are we here as tenant advocates? Or you're just looking for a fun evening out on Thursday? So tenants? Okay, a lot of tenants. Tenant advocates, you would consider yourself? Good, good. And then here for a good time? All right, no? Weird. Oh, there we go. All right. So I'll start with this. I am not a lawyer, and I make sure people are well aware of that when they call my office, because a lot of times they will have legal questions and things that are part of 562A, which is Jim's realm. I oversee housing code, which is part of the City of Iowa City. We're fortunate that we have a housing code. It's a minimum housing code, but it gives us a little more parameters that we can operate under. 562 will cover some of the same stuff that I cover, but the Iowa City Housing Code goes in a little more in depth and gives us a little more control. That being said, if you call my office and talk to me and I say, this is a legal question, I strongly encourage you to contact legal representation or seek someone with legal advice, you should do it. Like, I know enough to be dangerous, and I know enough to say, you've got an issue here, you need to seek some legal advice. And I tend not to go beyond that just because it's outside of my purview and I don't want to give you advice that would not be relevant to your case or might hinder you. So I'm kind of workshopping this presentation as well, so bear with me. We'll try to get through it and we'll cut things as we go probably. So we were talking about critical knowledge. So from the start, I think the biggest piece of critical knowledge for you as you're looking for a place to live in Iowa City is if you have the luxury of choice and you're down to a few, I would encourage you to reach out to our office. Now, I can't steer you and I won't steer you in any one direction, but I can tell you that I will give you all the information you need to make an educated choice about where to live. So you can ask me things such as, have you dealt with the property manager or this owner in the past? Have you taken legal action against this property owner, property manager in the past? Have you had complaints on this property in the past? All of this is public record. If you're super savvy, it's all available on our website. I would love to tell you that it's easy to get to and intuitive and all that. It's not right now. We're still working on some of that. The easiest way is to call us. We'd love to talk to you, and we can give you all of that information. We won't say, oh, I went and lived there because of this, but we'll say, well, this has been our experience with that landlord. We've had to issue civil citations to get the work done, or we've went as far as we've had rent abatement against this landlord because he refuses even after civil citations to do the work. Or in the past that we've seen multiple complaints on this property for various reasons. And we have all those, and we can give those to you. I think that's a critical piece of information to get into a good situation from the start. You want a landlord that you can work with. And sometimes if you have that luxury, that's definitely something you want to take advantage of. Jim did mention that a lease can be oral. It's the worst type of lease in my world ever, because I strongly encourage people to document. No matter what you talk to in person, make sure you keep a written record of it. Send it back to the landlord and said, as we discussed, this is what we discussed when we met, so there's no confusion over it. The example I have, if it's not in writing, it's not happening. Specifically, if a landlord says, yeah, we'll paint the apartment if it needs it when the old tenant moves out. Well, when the old tenant moves out, they're not going to paint it because they didn't need to paint it because they have it rented already. You rented it. So if you want that apartment painted and they've agreed to it, make sure you have things like that in writing. That's not really part of the housing code, but we get a lot of complaints about move-ins. This wasn't done. This isn't also part of the housing code, but it's also very important. We see a lot of questions about it. Read your lease. It's a big document. Don't be forced to sign something you haven't really read. There's a lot of information in there. They're going to tell you what you're responsible for. If you're living in a single family house or a duplex, there's certain situations where you're responsible for the snow removal. You're responsible for mowing the grass. It's a rude awakening when you're sitting there the first part of December and you found out that the sidewalk isn't cleared, and that's actually something that you were signed up to do. What's the start date? That one's usually pretty easy. We all get that one, but this last one is, when's the end date of the lease? Everybody assumes that it's going to go through the end of a month, but a lot of times landlords in Iowa City are shortening that up a little bit just to give themselves some time to get in there and clean the apartment and get it ready for the next person. So again, important things to note. Jim kind of touched on this as well, but establish a condition report for the apartment. The landlord probably is not going to supply you with a document to fill out. I would document all of that. If there's items that are wrong at the beginning of the lease period, get those in writing, get those to the landlord, and set clear expectations of when you want that fixed. So something goes wrong. Now what? Breathe, probably a good idea. Document the process. Use whatever process the landlord has set up. A lot of the apartment managers around here have online systems or emails or things that you're supposed to do. They're cumbersome, they're bureaucratic, they're designed to irritate you. I know all that. But the problem is, if you come to me first, the first thing I'm going to ask you is, have you given your landlord, apartment owner, a chance to correct it? That answer has to be yes. You have to let them know first before you come to the city and say, hey, there's a problem. The more documentation that you can provide me at that time, written communication is best. I know you maybe call them. Text is great. We can always screenshot a text, send it to the city, and it'll improve the timeline as we go along. It's amazing how quickly things can get fixed when we call. And I don't think we have magic powers, but I think they deal with this on a regular basis, and they know, oh, this tenant is serious. They've reached out to the city, and I'm not going to get away with it. So, yeah, always give the landlord a chance to fix it first, but after a reasonable amount of time, which can be a sliding scale depending on what we're dealing with, reach out to us, and we're happy to assist. For documentation of that, a lot of the property management companies in town have online systems. You can't rely on their online system as your documentation. So when you're sending that in, you need to screenshot that. You need to find some way to keep that in your possession. As Jim's saying, if you have those pictures but they go away, you don't have those pictures. That's the same way with those online systems. If they're the repository of that information, it's not going to be there. I mean, it's things happen. Technology is hard sometimes. And they're not going to provide you information that'll help you with your case. So, always just, trust, verify, keep all your own documentation. We talked about a reasonable amount of time to correct items. That gets kind of wishy-washy, what's reasonable. If you're without a furnace in the middle of the winter, you know, you should have some communication with your landlord immediately. They should be able to get someone out there within the day or provide you with temporary heat to get you through that breakdown. The unfortunate part is as our apartment stock ages, we're seeing furnaces that are at the end of their lifespan. Parts are hard to get a hold of, so those repair times are stretching out just because parts aren't available, and a lot of times they're having to replace. So we're having those conversations with landlords about the need to be proactive on their maintenance of HVAC equipment, and it hasn't been the most profitable discussion yet. Communication. One thing that I would encourage you to do as you move into an apartment is create clear lines of communication with your landlord. So, I think you can figure out early on, you know, the preferred methods of communication. Some is text, some is email, some may be phone calls. But, you know, right from the start, I would encourage you to keep a good, clear line of communication open with your landlord so you have some understanding of good ways to get in touch with them. So if you do have problems, that's taken care of ahead of time. I would also be very clear with your landlord of what your expectation is with timely communication. So if this is a situation, if you do this without a problem and he takes a few days to get back to you, you can say, hey, I emailed you, I texted you, is everything okay? I mean, I think early on, if you could set that standard of, hey, I expect you to respond to me. I'm renting a property from you. We have this forced relationship. I have expectations. You want my rent. I have you. I expect you to be responsive to me. I think that's all well within your purview there. I would encourage you to keep things professional and respectful. There's a lot of times we get into a situation where it's irritating. The heat's out, or it's the holiday and all of a sudden things aren't working. You have family in town. I get that. It's important not to get emotion involved with this and realize that we're all human beings. Let's just try to keep this at a very professional and respectful manner. There will be times that your landlord won't keep that it's kind of telling when it's in their text or when it's in their email. It definitely will help you in the future. Going back to that, documentation is key. If you've reached out to them and they're slow on responding, you provide that to me, we can act a lot quicker. If you haven't reached out to them, again, we're going to go back to that first step and say, hey, you need to give them a chance to correct it. And that first step isn't, I called them at 8 o'clock this morning and it's now 11 o'clock, I'm calling you expecting it to be done. It all comes down to that reasonableness factor. So, but yeah, that documentation part of that is key. I think you also get into expectations. So as you're out there looking for apartments, there's different levels of service at different places. You have private landlords who maybe do all their own maintenance. Might be a little folksy at time, little single-man shops. There's benefits to that. You also have private landlords that are kind of loosely affiliated in it. They watch that late night video on how to make money quick and buy rental property, and all of a sudden they have 2 or 3 rental properties that they don't know what to do with, and they've contracted out some. And I think it's good to get a feel as you move in of who you're renting from and kind of what their operations are. So third-party maintenance can be good, just because you have a professional that comes in and does it. A single operator, kind of a handyman trying to do all, could be good. They might be responsive, but they might not have the knowledge to do everything. You get into the big management companies, they may have on-site management and on-site maintenance, which can respond to things, but it might not be that personal service you're looking for. And then unfortunately, you might get to the point that this is the only place I can rent, and you're kind of stuck with what you have. So any of those situations, you have to figure out how to navigate that. So that kind of covers a tenant initiated, something was wrong with my apartment. I've reached out to the city. I've done my due diligence. I let my landlord know. And honestly, we get a fairly quick response from most landlords in town. And they might yell at me, or us, a little bit, but we're used to that. There's always some little grievance, and that's fine. They can have their little verbal outbursts, but the goal is to get the place fixed, get it safe. Sometimes it's a convenience factor. If it's a fire life safety issue, we're gonna act a lot quicker. If it's a heating issue, hot water issue, we're gonna act a lot quicker. Air conditioning, if it's present, it has to function. The efficiency on that gets a little bit tricky. And we're struggling with that right now as well. But if it's there, it needs to work. And if it's not working, they need to make provision for it. There's ample ways to provide temporary air conditioning to get through, the worst of it. So luckily actually in Iowa City, we have all of our apartments, all of our houses, you can open windows. There's not a situation where you're locked in an apartment that doesn't have access to air. So it's uncomfortable, it's not ideal, but you should be able to protect yourself that way. So let's talk about the flip of that, because I get to wear multiple hats as the senior housing inspector. I also oversee nuisance complaints. So there might be a time that I knock on your door and say, hey, guess what? You're doing something that people have complained about, which is, it's awkward sometimes. I don't take it personally. You shouldn't take it personally. I have given, notices of violation to many people, including city council members. It's fine. I won't name names. And it's, it's as simple as you should feel the same way that you feel about a parking ticket. It is what it is, it's part of living in the city, and there's these expectations. Most of the time, I would say there's no tiger. And if you don't know that reference, there's a character on social media called Neil Ford that puts out these little quippy videos, and he did a presentation and thought his world was coming to an end, and this woman said, there's no tiger. There's no tiger at the door. No one's dying over this. We'll get through it. It's fine. So most of the time when I knock on your door for the nuisance violations, there's no tiger. We'll get through it. So again, the key for that is communication is key. We want to help you. As much as you're not going to believe that in the moment, we want to help you, get through this issue. This isn't personal for us. And if you don't understand the issue, make sure you have us explain to you why this is such a big issue in Iowa City. We should be able to explain to you why we're there and why it's being enforced. The only thing that I would recommend is don't ghost us, because that's the worst, because then we have to escalate things and go through our bureaucratic process. I have here, it says, the only reason my neighbor is complaining about me is he's racist. And my response is, maybe. There's a possibility that is the case. We get pretty good about weeding those out. It could be just a case where your neighbor is just a curmudgeon who complains about everything and is just unhappy. Either way, we take those complaints, we work through them in a professional manner. I'll treat you professionally, you'll treat me professionally. If you need more time to get something done, ask me for more time. More times than not, I'm gonna say, yeah, can't mow the grass, not a problem, we'll work you through it. Sidewalks got some snow on it, got some ice on it. Yep, let's see what we can do to move that through and get that safe so kids can get to school and the people that are walking to work can get to work. So that's all I have. That's how I'm going to end. I need to work on my conclusion on that. But I guess we'll be going to questions. So I'll be happy. And I'll stay here afterwards if you have questions that you would like to ask, not in front of a large group. Hypotheticals that you might be dealing with right now, I'll be happy to meet with you privately so you don't have to spill all your stuff to everybody. Thank you.
My question is there an upper limit to the amount of money that they can charge you for not vacating at the end of the lease? So in my case, this is personal, but I didn't realize it was 7 a.m. was the move out, so it took me more hours. And they charged me $100 an hour. Is that legal?
Is this on?
Yep.
Yeah.
Okay. It's an interesting question. I've never seen that before. But if a tenant overstays their lease, the first question I would ask is, does the lease say anything about it? Does it specifically say, we're going to charge you something for being 5 minutes late in getting out? I would look at that if there were. And then what I can say is, if a tenant holds over after the lease is over, the landlord may have a strong claim to recover damages, right? And so a random amount, like, oh, $100 for every hour, that sounds pretty arbitrary. And so whether it's legal is sort of a different question. But as a lawyer, if I had a client asking me that question, I would be trying to, I'd be discussing whether there's could be any plausible, rational basis for this $100 an hour. And maybe a landlord would say, oh yeah, I have people, like I have a truck with movers and painters, and they're charging me right now because they were going to be in there painting. I don't know, I'm just making stuff up here, but it's possible if a landlord has some liability to a painter to be in there for every hour that they're sitting in their truck waiting to go in. This seems unlikely, but it's possible, right? So there's nothing specific in the law other than damages. What are their damages? If they're just completely arbitrary, that would probably be illegal. But if it's based on damages, might be fine. So while I'm at it, I wanted to mention one other thing that Stan's presentation reminded me of. He had good advice about read your lease, right? But I'm going to tell you, don't think you have to understand it, because I've seen 20-page leases that I'm like, what in the heck is that, right? And I don't sometimes know what it means, but I'm going to tell you this. If there are illegal provisions in the lease, and there usually are, I'll tell you that right now, they're not enforceable. So you're going to need a lawyer if there's a problem. You can ask a lawyer for advice. But the code is very specific. It says in 562A11 that a provision prohibited by this section that is nonetheless included in a rental agreement is unenforceable. Okay? So the fact that you agreed to it doesn't mean it's enforceable. You sign the lease, but if it's illegal, if it's prohibited, it's not enforceable. So something to be aware of. Don't let a landlord tell you, oh, the lease says I can keep your deposit no matter what. Well, maybe it says that, but it's not enforceable if it says that. So.
If you're moving and they say you can't re-rent your unit because they're going to remodel the unit, can they keep your deposit? Or can they give you your deposit back?
Well, I think you're asking me that, but so I'll just.
Yeah.
So there's the deposit section of the code is very specific about what the deposit can be used for, right? And they can't just keep it for the heck of it, right? They can use it if you didn't pay rent and you still owe some rent after you've moved out, you didn't pay it all, but they can use it for that. If you cause damage to the unit, it might be, normally they can take whatever the cost is to repair the damage. But there might be a weird scenario where, like, it's a really old apartment and they decided to completely remodel everything.
Exactly.
And like there might be some damage that a tenant caused, but they were gonna tear that out anyway.
Yeah.
Did they suffer damage? I would argue no, they didn't suffer damage, therefore they can't take it out of the deposit. They can't make the tenant pay unless the remodel was a necessity because of the damage the tenant caused. Like, it was really damaged. So we're gonna just remodel it. We wouldn't have done that if you hadn't done the damage you caused. So it can be complicated. It depends.
All of these things are what we call very fact-specific. So lawyers have a hard time giving blanket answers to some things because they depend on the specific facts of your scenario. So, but we can give you the general information.
So I have two questions that have to do with, I think, mainly with policy. One is most of the documentation, like the codes or some of the leases that people have to sign are usually in English. I know that the Equity Office usually translates a lot of the documents, but most of them that are supposed to be understood by tenants are actually in English. And there are many of us who have come from backgrounds where English is not our first language. And some of those include some of the things that Stan talked about, like some of the codes and what do I need to know about, what kind of maintenance or what kind of things the landlord is supposed to take care of. I don't know if there's a way we can go around that in terms of providing some form of training or opportunities for people to just know some of those basic codes or rules. That is my first question.
Yep, I can answer that. So there's one document you're supposed to be signing with your rental lease, which is called the Information Disclosure and Acknowledgement Form. And the city has provided that to all landlords in multiple different languages. And that should be the basic premise of when is trash day? Are you responsible for the lawn? Are you responsible for the sidewalk? Where can you park? What rooms are habitable? What rooms are bedrooms? So the city has done some of that already.
Okay. Yeah, I'm talking of detailed things such as like the things that are supposed to be security issues within the house. I don't know how frequently the city inspects all rental properties, and whether so some of those are they don't necessarily, because what I see is we're trying to look at preventative rather than as preventative. We should be looking at that rather than addressing issues as they come up. So if I, as a tenant, know that the landlord is supposed to have a GCFI in the kitchen area and so on, if I know, then I'll be able to say, hey, we don't have this. But if I don't know, it poses a danger, and until something happens, you wouldn't be able to know. So that's where my question actually comes back. What's the frequency of inspection, and how do I, as a tenant, besides some of those things that you have mentioned, know the things that the landlord is supposed to do?
So older buildings, we systematically inspect every year, and then newer buildings, and the best way to describe it is if it's sprinkled, it has the increased fire safety, it's inspected every 2 years.
And my other question is it's for you, Kristin. I realize that there's this gap between the state and the city. The county is supposed to be there. What is supposed to be the responsibility of the county in terms of housing? Because if, let's say, for example, you talked about the reasonable accommodation and how people can file complaints. So it means that if my city, for example, if I live in Tiffin and the city of Tiffin doesn't have your own office where I can file a complaint, then I have to deal with the state.
Right.
Okay.
We will help in that whenever anybody comes into our office, we're not going to say, oh, you're from Tiffin, go away. But we can't investigate that complaint. What we can do, though, is we can give you the state form, we can answer basic questions, and then we can take your state form that you've filled out and send it to the state for you. So, and then from then on, it's the state's responsibility to do their investigation, but we're not going to turn anybody away because you're outside of our jurisdiction. We just can't do any kind of investigation or anything like that. We'll help you as far as helping you get your complaint to the state. And when you said, what's the responsibility of the county? Well, what you were talking about was
why they don't have an equity office that can do the same for
Right.
cities that are not big enough to have equity office like the city, like Iowa City.
because that's the structure of the way the civil rights offices are in Iowa. This is kind of funny. It goes back to somebody who didn't want to lose their job. So the actual law is that any city with over 29,000 people in it, and people say, well, why isn't it 30,000? Why isn't it a round number? Well, it's because somebody wanted it to be over 29 so they could have their local office. A city with over 29,000 people has to have a local office, and if you're smaller than that, you don't have to have a local office. So that's why Iowa City has one and Coralville doesn't. And we are over time, so in the interest of people who are watching the live stream and that sort of thing, and who were promised an end at 7:30, I think we will conclude, but if you have further questions, please feel free to stay. I will be able to stay and answer questions, and so will Stan. I think Jim's available for a few minutes. Yeah, so please ask us anything you have to ask us, and otherwise, if you're watching online, thank you very much for attending, and thank you all.